Welcome back to Success with Steven. Today, I'm going to be answering two questions that I have been receiving quite frequently. First thing is, should you pay a collection account, and can a collection agency sue you? So if you guys have been following my videos, you probably have gotten a lot of collections removed, which is great. That's exactly what we want. If you haven't seen that video, how to remove a collection from your account fast in 2024, I'll put the video up here so that you can check that video out. Now, you're probably wondering, why would we be talking about paying a collection if you're able to get them deleted quickly, right? There are situations where people may look at paying a collection for various reasons. For example, if you had an account with, let's say, a bank, and it was an account that was charged off, then created as a collection, you may still have to go back and maybe pay that account off with that bank so that you can maintain that relationship and that you can still get products and services with them. That would be a situation where not really paying that collection per se, but where you're paying directly back to the creditor, even though they sold the debt to a collection agency. That's not always the case, but that's just an example. And can a collection agency sue you? And I think that was one of the other biggest ones because we've been getting a lot of these collections deleted. But people know that there's a difference between a collection agency and a debt buyer. And a debt buyer usually will purchase an account with the intention to sue. And that's one of the main things that I wanted to address, because in that situation, some people may want to pay the account because they're afraid of the lawsuit. And I wanted to talk about that, and I wanted to share some great information that I think will actually be very helpful. So if you haven't subscribed to this channel, if you're new to this channel, welcome. Leave a comment letting me know that you're new so I can welcome you to the Success family. Again, here we're all about financial literacy and maintaining a good, transparent strategy to fix our finances, right? One that everyone can actually use. All right, so we're gonna start with I like starting with the good news, like the tips. Like, I like starting with the things that can actually help people on the front end, because that's the most important information to me. I don't want to lead you, so let's go ahead and start with that. Now, this is the good information that I was telling you about. On most collections that I've dealt with, and not all, but most, are credit cards. And what I want to talk to you about is the statute of limitation on debt collection, and I want to talk to you by state. So one of the things that a lot of people don't know is a collection agency has a certain amount of time that they can sue you. And sometimes a collection agency will threaten you with, we may be considering pursuing legal action against you, but the statute of limitation has expired. And the crazy part is, you can actually go to court and the statute of limitations could have already passed, but they can still win if you don't know that. So that's information that you need to check. So for example, if you received a suit in the mail and we look up your state and we find out that the statute of limitation has expired, you can go to court with all confidence that you were perfectly fine and nothing's going to happen to you because you have this information. So we're going to break it all down here right now. All right. So for statute of limitation on debt collection by state. So the statute of limitations on debt typically ranges 3 to 6 years, depending on the debt and the state that you live in. All right. So what is the statute of limitation on debt? A statute of limitation on debt limits how long creditors or collection agencies can only take legal action against you to collect a debt. The length of that period depends on the statute of limitations in the state where the debt originated. So keep that in mind. The statute of limitation depends on the state that the debt originated. Statute of limitations are laws that govern the deadlines for certain legal actions, but don't be mistaken. You aren't off the hook for a debt just because the statute of limitation has passed. The debt might still show up on your credit report. If you don't pay it, you could face trouble getting future credit, especially a mortgage. As we know, we have our strategy and our methods to delete collections off of our credit report very quickly. So that's a good thing. So we're not too worried about that per se. The statute of limitation does prevent you from being successfully sued for time bar debts. That means the creditor won't be able to get a judgment against you that allows them to garnish your wages or levy your accounts. So that's important. When we go over the statute of limitations per state, pretty much if you're out of that time frame, they can't they can I want to make this clear. They can still technically sue you, right? But if you know that the statute of limitations has expired, when you go to court, that's all you have to say and it gets tossed out and you're done. That's it. Um, they can't garnish your wages. They can't levy your account. They can't take anything from you. So the 4 types of debt that we're dealing with are oral agreements, written contracts, promissory notes, and open-ended accounts. Now, you rarely see oral agreements, so I'm not going to really go over that. That's the proverbial handshake agreement, and it's really uncommon. That's something that you would deal personally with like your family or something of that nature, and it's very hard to prove an oral agreement. Written contracts are the most important ones that we're going to be looking at. So, written contracts detail a lending agreement including the borrowed amount and date, the purpose of the loan, the interest amount, when and how to make a payment, and other terms. Both parties involved in the contract, the borrower and the lender, sign the document to validate it. Written contracts are easier to prove than oral contracts. Vehicle loans are written contracts. Medical debt or payments for services you agree to in writing are also written contracts. All right. So keep in mind that when we're looking at this and we're looking at the statute of limitations for your state, there's going to be a section for written contracts and there's going to be a section for the other one we're going to focus on, open-ended contracts. So promissory notes, they're similar to written contracts, but with less detail. And in addition, they only need to be signed by the borrower to be enforceable. You generally sign a promissory note when you take out a mortgage or student loan. So just so you know, that's a promissory note. But the open-ended one is the other most important one next to a written contract. So open-ended accounts, typically, these are revolving accounts such as credit cards, lines of credit, and open-ended accounts remain open for an undetermined length of time as long as you are making regular and agreed upon payments. You can also carry a balance on these accounts as long as you make regular minimum payments. All right. So again, most people that are looking at these, or at least from what I'm seeing when I do one-on-one coachings, when I'm answering questions, we're usually looking at either written contracts or open-ended contracts. Now let's go over the statute of limitations by your state. So for example, if you had a credit card debt and the credit card debt was in 2020, that credit card debt was sent to a collection agency. If you've gotten that collection removed from your credit report and they're still trying to contact you to pay that and they're threatening you with legal action, open-ended contracts are 3 years. So the thing is, after 2023, they couldn't sue you. They can't. So you don't have to pay them anything. So in that type of situation, if you're asking me whether or not you should pay a collection or what do you do when a collection agency sues you, well, the first thing I would do is check the type of account. If it's a credit card or it was an open-ended account, check the statute of limitation for your state. If it's 3 years and they're contacting you in 2024 and this was a 2020 account, you don't have anything to fear. Go to court. You need to go to court and take care of it, because the number one reason that people lose when it comes to these debt collection lawsuits is because they don't show up. That's the number one reason, because you did not show up. That's it. They give you a default judgment. When you have a default judgment, because you weren't there to say whether or not something was true, it wasn't, you just basically forfeited your right to oppose it. Don't do that. Always show up. Always show up every time. So for a written contract, it's 6 years. So if you had a vehicle in, let's say, 2000, 2015. And for whatever reason, it went to collections. By 2021, that open-ended account, or I'm sorry, that written contract agreement, they could no longer sue in the state of Alabama. And then in your 7th year, it would be coming off of your credit report. So just, the 7 years still applies for your credit report. But again, we work on deleting stuff and removing that. So you already know the options you have to get it removed or deleted. But when we're talking about litigation and possibly getting sued, we need to know these time frames at which we have to worry about. So let's just go through a few of them. Alaska, written and open-ended, is 3 years. Arizona, written, open-ended, 6 years. Arkansas, written and open-ended, 5 years. And then California, 4 and 4. I'm going to look for some states that are really big, like Delaware, 3 across the board for everything. Kentucky, now that one's a little bit different. As you can see, the written in Kentucky is 10 years. So hey, here's the thing. And the open-ended is 10 years. So here's the thing. If you were looking at like a 10-year contract per se, and it was a debt buyer, and first, let me say this, always consult an attorney. This is not financial advice, and this is for entertainment purposes. But no matter what, I would always consult an attorney. Reason being, sometimes some of these debt buyers who buy big accounts with the intention to sue can't even sue in your state. That's why you need an attorney to take a look at it and tell you whether or not you should pay, or tell you whether or not they have the legal recourse to even do it. But the most important thing is show up to court. You need to show up. All right. So 10 years lets you know, hey, maybe, if it's that length of time, they can get me. Louisiana, right here, open-ended is only 3 years. Written is 10. But open, which is, again, most of the accounts that I end up talking to people about as far as like collections, are old credit cards that got charged off and then sent to collections, and then they got them deleted. Now they're getting letters and stuff saying that they might sue them. Well, if you're in Louisiana and it's already been 3 years since that account was sent to collections, well, they can't sue you. So you don't have anything to worry about. So what I'll do is I'm going to link this at the bottom in the description, so that you can actually have this information and you can look at this. And then maybe if you were getting, like, let's say letters in the mail or something like that, you can, because your collection we deleted it, and now you're saying that you're getting this in the mail. They're threatening you with, this is the first thing that you need to check. Very, very first thing. Look at your state. Look at the type of account that it is. What's the statute of limitations on that account? And then even if you're in the statute of limitations, check and see with that collection agency if they even have the right to sue in your state. These are all just things that you want to, go ahead and do. And if all of that happens and the amount is substantially large, then I would look at consulting a attorney that specializes in dealing with debt collectors and collection agencies. That's the steps I would take to deal with this if it were something that happened to me personally. So, when does the statute of limitation clock start? So, according to the Federal Trade Commission, the FTC, the statute of limitations clock starts when you fail to make an agreed upon payment. However, you can reset the statute of limitation clock in some cases by making a payment on the debt or agreeing to make such payments in response to a debt collector contacting you. This is why I said in my video about how to dispute a credit report, you don't make any agreements over the phone. That can reset the clock on that charge off, that collection. You don't make any agreements. Don't make a payment. Don't do any of that, because doing that can do this and reset the clock. So if you had a collection and you made a payment on it, well, now everything resets. But keep in mind, the statute of limitations starts the day you don't make the first payment. So if you didn't make the first payment in 2019, if this account is a collection in 2024, depending on where you fall from that date, the first late payment, you may not have anything to worry about. And this is why a lot of this stuff is really intimidation tactics, and it's meant to scare people because they don't have the information to know whether or not they need to be worried about it, and they get you with fear to have you pay them, even though that creditor, the original lender, received a corresponding tax credit. So when you're looking at this, if you believe you owe somebody money and you want to pay them, then you pay them. But understand that when we're talking about business and we're talking about the law, sometimes with collection agencies and lenders, there are illegal practices where they actually do make money two or three times off of the same debt. And there is a system in place that preys on people with subprime credit, and sometimes they put them intentionally in situations to become a subprime lender so they can give you these predatory interest rates and then make money off of you, with these corresponding tax credits, and then also having you pay again on top of that. So it's a lot that to like break that down. But the point is, when you're doing this, make sure that if you make a payment, it makes sense. Don't agree to make a payment unless you've done your due diligence. Don't make a payment unless you've done your due diligence and research on this account, because everybody's making money off of you. And I would hope that, or I would think, if you were in a situation where you couldn't pay, there was a reason for it. And now we're trying to clear all this up, because whoever I was 3 years ago, I'm not that same person. I'm in a different financial space. I'm in a better place. I'm just trying to settle everything. I just want to get this cleared up. And then it's like, if I want to get a house and you won't pay to delete, I got to get it off some way. Like, people have things they need to do. They have family, they have kids. They need to get a bigger car to transport them. They need to put their sick mom in a house. People got things that they got to do. I understand that, right? So we're not going to let little things like this hold us back, especially when people already got paid. They already got paid. So make sure you don't reset the clock on your statute of limitations. Delinquent debt and your credit report. So in most cases, negative items such as delinquent accounts or unpaid collections will fall off of your credit report after 7 years. Remember, it still falls off in 7 years from the date that the account first became delinquent. And as you can see from the table above, many states' statute of limitations are below 7 years. That's the main point that I want you to understand. Again, they're below 7 years. So that means that your credit could reflect an account that is past the date of legal collection methods. If you legitimately owe the debt in question, your choices include pay the debt off to have it showed up as paid. We're deleting that. Try to negotiate with the creditor, potentially a pay for deletion, which sometimes works, but we're deleting that regardless. Or you could wait for the item to fall off. And why are there statute of limitations on debt? I think that's important. Statute of limitations sets a time for when debt collectors and creditors can take legal action against a borrower who defaulted on their debt. After the statute of limitation time has expired, creditors and debt collectors can no longer file a lawsuit to collect on the debt. This limitation helps protect borrowers from being liable for old debt. So what happens after 10 years of not paying debt? Typically, 10 years of not paying debt, the statute of limitation will have passed, and this means that you technically still owe a debt. Debt collectors may try to contact you, but they typically cannot pursue any legal action against you. And we know it varies by state, and we know that you should talk to a tax professional if anything is going on. I live in the state of Nevada, and I just had pulled up the debt collection laws in my state. I know we all live in different states, but I just wanted, and I can't go over all 50 states, so I just wanted to look at some of the debt collection laws just so that you understand, and you know that you can go to your Secretary of State website for your state and you could look up this information. So, Nevada debt collection laws. Nevada has comprehensive regulations limiting how a debt collector may attempt to collect, in addition to the rules and restrictions for debt collectors established by the FDCPA. Now, this is basically the rules of how someone can collect debt on you in this state. Nevada debt collection laws forbid, among other things, the following practices by collection agencies. So if any of these things happen to you and your rights have been violated, you can take legal action in response. Number one, utilizing deception, deceit, or fraud to collect any debt. Number two, sending out any notification of collection that appears to be coming from a government agency or imitates legal procedure. They can't do that. That's illegal. Harassing a debtor's employer while trying to collect or recover a debt. Operating a collection agency from a location that isn't permitted. Look at that one too. Collecting any interest charge, fee, or expense that is incitable to the principal debt. So they can't take any incidental amount that you actually don't owe and then add it on. So for example, if you looked at your original debt was $800, but now it's $950 because of a interest fee, that's illegal. They can't do that. Whatever the original principal amount was, you can't add anything onto it. That's another thing. So collecting any interest charge, fee, or expense that is incidental to the principal debt may be collected or may not be attempted to be collected unless the payment, interest, or fee is permitted by law as agreed upon by the parties. So the charge, interest, or fee has been determined by a court to be appropriate, lawfully payable, and chargeable against the donor. The collection agency has charged the cost, interest, or fee to the principal after describing it in writing as an agreement between the parties. So number 7, engaging in unlawful debt collection is against the law. According to the law, any debt collector who gives a debtor reasonable grounds to believe that failure to pay the obligation on time may result in using force or other illegal means, you can't be threatened into paying a collection agency. Abusing the debtor or tampering with any of their possessions. They can't tamper with your property. They can't touch you. Illegal. Number 9, law. So these are Class B felonies. Any of these offenses are Class B felonies with hefty fines and jail sentences ranging from 1 to 6 years. But the thing is, you would want to, again, that's you consult an attorney. If you, and in these comments, you guys are probably going to ask me questions. I can't answer any legal questions for you. So if you ask me those questions, I'm just letting you know I can't respond to them. I can't respond to them. So I would say if you have any legal questions, you need to consult an attorney at that point. Because I couldn't answer that for you. But yeah, that's pretty much all the laws. I would say go to your Secretary of State and check how these laws apply to your state, because if you do have a debt and it is within the statute of limitations, you could look at one of these reasons to get that thrown out. Okay? So you definitely want to take a look and see what's going on. And this is just a little more information that I had pulled up from the CFPB. This one is pretty much the exact same information that we were just looking over, letting us know that debt collectors, if they can collect a debt that's several years old, and of course we already looked over the statute of limitations, so I'm just going to skip that. We don't need to reiterate it anymore. And let's do, because this is the other most important thing, because I really want to reemphasize this. What should I do if I'm sued by a debt collector? If you're sued for an unpaid debt, you should respond to the lawsuit either personally or through a lawyer by the date specified in the court papers. So if you have been sued or served by a creditor or debt collector for an overdue debt, read the lawsuit carefully, respond by the required deadline. By taking this step, you can protect yourself and help avoid additional financial difficulties. Now, this is why is it important to respond? When you respond to the lawsuit, a debt collector has to prove to the court that the debt is valid. That's important. They have to prove that the debt is valid. If you owe the debt, you may be able to work out a settlement or other resolution with the collector. So check this out. Even if you go to court, there may be a way that you can cordially come to an agreement to settle the account, even at that point. When you don't show up, automatic default judgment. They're going to garnish your wages or levy your accounts. You don't want that. So, responding doesn't mean you're agreeing that you owe the debt or that the debt is valid. It doesn't, just because you respond doesn't mean that you're saying that you are guilty of anything. If you don't respond, the court can issue a judgment or court action against you, sometimes called a default judgment. For example, if you refuse to accept delivery or service of the lawsuit, the court could view that as ignoring a promptly served lawsuit, and it's unlikely this tactic will be effective at defending yourself against the lawsuit. As a result, it is likely that a judgment will be entered against you for the amount that the creditor or debtor claims that you owe, as well as lawful additional fees to cover collection costs, interest, and attorney fees as allowed by the judgment. Judgments also give debt collectors much stronger tools to collect the debt from you. You may lose the ability to dispute the debt if you believe that you don't owe it or that the amount is wrong, and depending on your situation and your state laws, the creditor may be able to garnish your wages, place a lien against your property, move to freeze funds into your bank account. So a judgment is a court order, so it can be very difficult to change it or set aside once the case is over. You have a better chance to fight a collection in court if you defend the case than if you were to wait until the judgment is entered against you. You may also be able to work out a compromise or settlement by negotiating the debt collector before a court makes a judgment. So there you go. Even if worst case, you can either get your lawyer or personally make a settlement agreement with them, and you can sell it that way. So when a debt collector can't sue or threaten to sue, and that's where we were going over the statute of limitations. The final thing that I have for you here, which I'm going to leave a link to this, is how do you find a lawyer to help you with a creditor or collection trying to collect a debt from me. Now, me personally, I like to go off of recommendations or, looking at particular profiles, maybe even social media, and looking at comments for results. I think you get more real feedback when you look for real people who actually had to deal with this person. But this is a good place to start. So attorneys experienced in consumer law or debt collection can help you understand your state and federal rights. If you have a debt in collection or have been sued by a debt collector, it may be helpful to find a reputable lawyer to advise or represent you. Under federal law, a debt collector must go through your attorney if they know that you have one, so it's a good idea. So if you get legal representation, they have to talk to them. They can't go through you. So to tell the collector the name of the attorney who's representing you and how they can contact them. If the lawyer doesn't respond to a communication from the debt collector in a reasonable amount of time, the debt collector may contact you directly. And then, of course, how to find a lawyer to represent you. So you can find lawyer referrals in your area by checking the American Bar Association website or your state's bar association. And there's also state-based legal programs for low-income consumers. So let's take a look at that really, really quick. So let's go to the JAG Legal Assistance Office. So right here, there's one for the U.S. Armed Forces where you can look for legal representation by filling out this information here. So you pick your state, you pick your branch, you would then search, and then you can find an attorney that can represent you. And then let's go back a little bit more here. Let's go to our state-based legal attorney, and then let's check for the legal aid website. So I'm going to leave a link here too for legal aid. Some attorneys may offer free services or charge a reduced fee. There may also be legal aid offices or legal clinics in your area that will offer their services for free if you meet certain criteria. Sometimes they do it for free when they do have a case where they can countersue. So that way, as opposed to you having to pay, they will be able to make some money from this. And then in that case, they will take your case for free if it meets certain criteria. And then here are the different states of different law offices that provide legal aid. My suggestion would be start here. Maybe see if you can get any legal aid for free. There's also, again, you can check social media. You may find people who also do this for free. There's a lot of lawyers who end up doing a lot of cases for free if their case, if meet the right criteria, means they look at this as an opportunity for a countersuit, and there will be compensation that they can get. It just, your win would pay them as opposed to you having to pay them directly. So, I mean, I would say that's actually a pretty good deal. And I'll make sure to put this in the description too. This link for the CFPB for legal aid that you can possibly get, and I'll put the one before that one, so you can look at the bar association that corresponds with your state, so that you can get free legal representation. They probably have a free consultation if you want to talk to anybody who may be able to address, any concerns that you have. So for us to wrap this video up, I just want to make note that in the chance that you do get sued, this is a good video to refer back to. Check your state statute of limitations. Check if any of your rights have been violated from the previous step that we were looking at. And then also, if all else fails, look at the legal aid that you can get for a free attorney. All right. So those are the main things. And should you pay a collection? Ultimately, there really is no right answer. It just depends. If you're out of the statute of limitations, then we know you don't have to pay. If you want to pay, you can pay, but you don't have to. Legally, you're not obligated to pay if you're out the statute of limitations. I hope that helps a lot of people, and they find that for open-ended accounts or some of their written contracts, they're out of that statute of limitations, so it puts their mind at ease if they're receiving any type of letters or emails from collection agencies. So, just keep that in mind, because I'm sure that a lot of you are outside of that time frame, hopefully for the most part. And then that should be it, man. If you guys have any questions or concerns, drop them at the bottom of the video. Please let me know if this information was helpful to you. I would also like you to leave a comment. And if you were out of the statute of limitations and you were getting contacted, can you drop a comment saying I'm out? And we'll just see how many we could get. I'm out. I'm out. So that information is power. You use the information that you got to defend yourself, in these situations. You were able to get out of a situation that maybe you felt threatened by, or maybe you felt it was bigger than you. And now with a little bit of information, you were able to overcome it. So please let me know at the bottom, again, if that helped. If you're out, say I'm out. If you have any other questions, please leave them at the bottom. Again, any legal questions, I can't help you. I'll probably refer you to the legal aid. So maybe there's a free consultation for an attorney for you. But other than that, guys, thank you for the questions. I was more than happy to address this one because it has been asked pretty frequently. And I'm glad that I had the time today to go ahead and make this for you. And you guys have a wonderful day.